About 50 years ago, Supreme Court Justice William Brennan issued a call to action to judges on the state level. It was a period when American democracy was regressing amid a rightward shift on the Supreme Court, much like today, but with much lower stakes. Brennan urged state courts to step in and fill the gap left behind by the high court, writing, quote, "State courts cannot rest when they have afforded their citizens the full protections of the federal Constitution. State constitutions, too, are a font of individual liberties, their protections often extending beyond those required by the Supreme Court's interpretation of federal law." For Brennan, the U.S. Constitution was a starting point, a foundation upon which rights and protections could always be expanded by state courts. It was a groundbreaking idea at the time, leading to a legal movement dubbed the New Judicial Federalism, which relied on state constitutions rather than the U.S. Constitution to widen the scope of rights. The journalist Eyal Press noted this month in The New Yorker that in the decade following Justice Brennan's appeal, state courts issued over 200 rulings that expanded individual rights. In today's day and age, the need for state courts to step up once again has never been more urgent. The threat to our democratic foundation looms large as an extremist fringe, now in control of a major political party, imposes its radical conservative agenda on our federal institutions. And nowhere is this more evident than at the United States Supreme Court. From the overturning of Roe v. Wade and the gutting of voting rights to undermining the authority of the Environmental Protection Agency, this court has waged a relentless assault on civil liberties and federal regulations that are designed to protect American citizens. The inability of a hamstrung Congress to hold the Supreme Court accountable for a string of ethics violations and forum shopping underscores this urgency. Over the next generation, legal experts say the battle to save our democracy will be waged in state courtrooms. Americans aren't really accustomed to thinking of state constitutions as an additional check on our system of government, but throughout our country's history, there's been this tug of war between state and federal powers, with one stepping up when the other falls short. Americans forget that state courts have at times been key drivers of social change and progress in America. For example, same-sex couples began marrying in Massachusetts state courts in 2004, more than a decade before the federal Supreme Court recognized that right. When the Supreme Court gutted abortion rights in Dobbs 2 years ago, several states stepped in to protect women. You often hear about red states striking down abortion access, but numerous states also moved in to protect abortion rights. 4 states amended their state constitutions to include that right. 14 states are holding similar referendums this upcoming November. Meanwhile, 11 states recognize a right to an abortion independent of the U.S. Constitution. On the issue of voting rights, where the Supreme Court has notoriously rolled back protections, the Montana Supreme Court this year struck down voter restrictions that critics said discriminated against Native American communities. State courts are also taking the lead in the fight against climate change. Hawaii recently affirmed a fundamental right to a clean and healthy environment, something that federal courts have denied exists. In his opinion, the Hawaii Supreme Court Justice Michael Wilson did not mince words, criticizing federal courts for abdicating their responsibility on this issue. Quote, "The Hawaii Supreme Court," I'll read it from here, "The Hawaii Supreme Court does not choose to throw up our hands. In contrast to the federal judiciary, the Hawaii Supreme Court has recognized the constitutional right to a life-sustaining climate." The American people recently witnessed the power of state laws in action with the New York hush money cover-up case. Donald Trump was found guilty on 34 counts, making him the first American president ever to be convicted of a crime. For years, federal mechanisms failed, one after the other, to hold Trump accountable, from 2 failed impeachment trials to the conservative Supreme Court interfering in his federal election interference trial. Trump always managed to wriggle his way out. Not this time, my next guest, Kermit Roosevelt, writes. Our noble Senate, our hallowed Supreme Court, our sacred Constitution, none of these things protected us from Trump. On the whole, they enabled him. In the end, Roosevelt argues, it was ordinary state laws that finally caught up to a disgraced ex-president. The reason Trump was finally held accountable was not that he ran afoul of special rules that govern the highest reaches of our political system. It was that 12 ordinary Americans in an unglamorous trial courtroom ruled that he had broken the laws that everyone else has to follow. State law that applies equally to all did what the special rules of the Constitution could not, end quote.